My name is Catherine Brown, and I'm here to discuss immigration law nuts and bolts, what every lawyer should know. And essentially, I'm going to present what we just talked about for the last hour in about 3 questions. I get a lot of questions from both U.S. citizens and foreign nationals about certain things. For instance, how do I bring my wife or child to the United States? The answer to that question is fairly loaded, and I will try to explain it as briefly as I can. But essentially, our procedure is a 2 or 3-step procedure in order to do that. Usually the person is standing abroad, and we have to petition for the person to ensure that they are eligible to obtain a visa at a U.S. embassy. When you petition for someone, you essentially have to prove your relationship if you are a family member, or if you're an employer, you need to prove that the person meets certain requirements in order to bring them here. If your petition is approved, then essentially you will be eligible to bring the person to the United States. That person must be what we call admissible, meaning that they meet certain screening criteria before we let them enter the United States. Under the Immigration Nationality Act, we have several grounds of inadmission or admissibility rules. They're found at 212A2. In a nutshell, several rules of admission pertain to crimes, prior immigration violations, misrepresentation, health, and finances. If the person you're bringing over is a spouse or U.S. citizen, you must meet all these visa requirements in order for them to come to the United States. Once they come to the United States, then they are again screened through the border CBP, which is Customs and Border Patrol. And then once entered the United States, they can obtain their resident alien card. Another question that people ask frequently is pertaining to the undocumented community. And a lot of people, friends, neighbors, even co-workers, might work with someone and they want to help that person, and they come to me and they ask, how can I help someone become legal in the United States? Again, this is a loaded question, but it's essentially difficult to answer given the person's status. The first question is whether they entered with a visa, a legal entry, or whether they entered illegally. This will help us to determine if the person's eligible for any kind of benefit in the United States or not. If they are ineligible for any kind of benefit in the United States, they will have to leave the United States and obtain a visa if they have a relationship that allows them to get a visa. If they've had too much what we call unlawful presence in the United States, then they will be inadmissible when they try to obtain their visa. Some may be eligible for waivers, but those are only people that are closely related to U.S. citizen permanent residents. So in other words, a lot of times we can't do anything for these particular people because the penalties are too difficult for them to exit, or they don't have a right relationship at this point in time to get a visa. They will not be able to obtain a visa in the United States because they haven't been maintaining their status, or they haven't entered with a legal visa to begin with. Finally, a question that's asked fairly often from people who don't understand our immigration system and need assistance is a decision was wrongly made or their case was denied. And they ask, how can I correct this, or how can I appeal it? And the answer is that it essentially depends on what agency you're dealing with. We deal with lots of different agencies in immigration, predominantly Department of Homeland Security, which houses USCIS, CBP, and ICE. USCIS deals with affirmative benefits, CBP with the border, and ICE is our interior police. The other agencies we deal with are U.S. Department of State, who control the issuance of visas, and we also deal with the U.S. Department of Justice and the U.S. Department of Labor. In any event, those agencies have their own procedures for review, for decision-making, for review, and for appeal. In some situations, there clearly is no appeal process, because this is a situation where Congress has dictated that certain non-citizens will not have appellate review. Immigration law is completely under congressional authority, or what we know as the plenary doctrine. And as such, there are no constitutional rights that equate to U.S. citizens in the same fashion, but for very few. As such, Congress can dictate what kind of rights can be curtailed and when. Sometimes when people ask for what kind of visas are available to me, I have to explain to them that it depends on what type of visa they're applying for. Essentially, immigration law breaks down visas into two types: temporary visas and permanent visas. Permanent visas are also known as green cards in the slang. Temporary visas are your people that want to come here for a fixed purpose and a fixed duration. Your visitors, your students, your temporary workers. They essentially can extend their status or change into a different temporary status, but they cannot stay here indefinitely on that type of visa. They eventually must leave. A permanent visa holder is a person who's a permanent resident alien, and they are allowed to stay in the United States indefinitely. It's not easy to obtain a permanent resident visa. However, there are alternative avenues besides families and employers. In some situations, people that are victims of crimes or abuse can apply for what we call self-petition green cards. We also allow green cards to be processed for people with very high skills and lots of wealth. But in any event, the green card process is more long-term and is much more complex than obtaining a temporary visa. What usually happens is someone comes on a temporary visa, they become settled in what they do here, whether it's at work or with personal relationships, and then they apply for a green card either through a spouse or an employer, and they adjust status in the United States, which is a procedure allowed for certain people who've maintained status, or if they haven't maintained status, they're spouses of U.S. citizens or children of U.S. citizens, and are allowed to adjust status regardless of the fact that they have violated their status or overstayed their time.